Hello, everyone. This is Stacy Bowman. I'm an attorney with Husch Blackwell's Healthcare, Life Sciences, and Education Industry team. I have an active litigation practice in both state and federal district courts. I represent clients in commercial contract disputes, insurance coverage claims, and business torts, and naturally my experience includes labor and employment litigation. We are very excited to give today's presentation. We are going to focus on how to effectively communicate with your attorney, whether in-house or outside counsel, without waiving the attorney-client privilege. We will also discuss hypotheticals and debunk common misconceptions about whether a communication is protected from disclosure in litigation. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons that you can use during today's webcast. Let me highlight just a few of the key icons for you. Questions. If you have a question during the webcast, we encourage you to submit them. We really appreciate audience participation. You can submit a question using the question box. We will try to answer all questions we can during the webcast today, but if a more comprehensive answer is needed or if we run out of time, we will answer your question later via email. There is also an icon to assist you with your viewing preferences. Please note you can expand your slide area by clicking on the maximize icon on the top right of the slide area, or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click the Help icon. It has a question mark, and it provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the Resource List icon. It looks like a folder at the bottom of your screen. Now, concerning credit, this program has been approved for continuing legal education credit in the following states: Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. Now, a couple of these states, you're going to need to click on the CLE widget at the bottom of your screen and complete the questions. These special states are Illinois, Nebraska, Tennessee, or Texas. So if you are seeking CLE credit in those states, again, that's Illinois, Nebraska, Tennessee, or Texas, you have to click the CLE widget at the bottom of your screen, answer some questions, enter your bar number, and this needs to be done before the webcast concludes. This program has also been approved for HR Certification Institute and SHRM, that's the Society for Human Resource Management, recertification credit. A recording of this webcast will be available tomorrow for watching and sharing. Once it's available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today is Benjamin McMillan. Ben also practices in the area of labor and employment law, counseling private and public employers on a wide range of workplace issues, including labor unions, compensation, terminations, safety, and discrimination. And like me, Ben has a very active litigation practice and has handled many arbitrations. With that, I'm going to turn it over to Ben to start us off.
Well, thank you, Stacy. I know I speak for Stacy as well. We are delighted to have all of you here today to hopefully allow us to give you some insight into what is frankly a complicated topic. It's a topic that is widely misunderstood by human resources professionals, but also by attorneys who often have to make decisions as to what documents should or should not be produced. So it is certainly our goal to shed some light on that for you, and we hope that today's presentation is helpful. I want to start with a troubling tale, and it is the story of Wally's Widgets. There's a big problem at Wally's Widgets. A high-level sales employee, and Mr. Calvin Creep, and there's a picture from last year's Christmas card that Calvin sent out. He was a high-level sales employee and accused of serious sexual harassment by a fairly new employee, a Miss Valerie Victim. Human Resources initiates an investigation, talking with several employees, and preparing detailed notes. As the investigation unfolds, HR decides that Larry Lawyer, the company's in-house attorney, should be clued in on the happenings. Now, an HR specialist, a Ms. Irene Inspector, who you can see there on the left, prepares a detailed email summary of the investigation. That summary includes some very damaging information. She sends the summary to her boss, Connie Compliance, who is the Director of Human Resources. She also copies Larry Lawyer and Sally Sales. Sally is the Sales Department Director. The subject of the email states, quote, FYI investigation summary, end quote. Body of the email says things like, quote, my plan is to follow up with Valerie, and, quote, I think we should suspend Calvin immediately. His behavior was inappropriate. At no point in the email does Irene ask for anyone's advice or input, including Larry's.
So Connie Compliance replies to all saying, I agree with your plan. Good work, Irene. Sally Sales, by contrast, replies to all with, hold on, Calvin is one of my biggest producers. Let's not be so quick to suspend him because he has a huge sales call in a month. We just have to have him there. So an exchange unfolds on email where Connie and Sally are debating whether Calvin should remain an active employee or be suspended. Although Larry Lawyer remains copied on the entire exchange, he never chimes in. Unbeknownst to everyone, Larry is out of town for a 3-week jury trial involving an allegedly defective product produced by the company. Ultimately, Sally Sales wins out and Calvin remains actively employed. Irene is told to table her investigation until after Calvin's big sales call. In the interim, however, Calvin terminates Valerie Victim's employment, claiming that she is not a team player and, quote, not committed to what we are trying to accomplish, close quote. As expected, Valerie files a charge of discrimination with the EEOC and ultimately a lawsuit.
When the outside lawyers for Wally's Widgets, folks like Stacy and me, send a copy of the lawsuit to Larry Lawyer, again, in-house counsel at Wally's Widgets, they also include the plaintiff's first request for production of documents and a brief summary of the information sought. Included in that summary is a request for, quote, any and all documents related to any investigation of plaintiff's complaints about Calvin Creep, end quote. As Larry works with HR to collect the requested documentation, he stumbles across the exchange on which he was copied, but to which he never responded. Again, he was wrapped up in a jury trial. Whew, Larry says, I'm glad the entire exchange is protected by the attorney-client privilege. Larry facilitates the production of thousands of documents and moves on with his life. Months later, during Irene Inspector's deposition, she testifies that she sent an email summarizing her investigation to Connie, copying Sally Sales and Larry Lawyer, and casually mentions that Larry Lawyer never responded. Valerie's attorneys identify the exchange on Wally Widget's privilege log and request a conference with the court. They're foaming at the mouth at this point, wanting to get their hands on that document. During the conference, the judge asks to see copies of the exchange, which Larry happily provides to the outside lawyers. As you can see, Your Honor, the lawyers convey at Larry's behest, the entire exchange is privileged because Larry Lawyer was copied throughout. Is he right? Now that question is one we hope to answer for you today as we discuss this very important and misunderstood topic with you. Let's start with some background information about the attorney-client privilege. The privilege, which is widely known, but again, widely misunderstood, protects certain, emphasis on certain but not all communications between a client and his or her attorney, and it keeps those communications confidential, i.e. protected from disclosure in litigation or otherwise. Now, as indicated, this is one of the oldest and widely recognized privileges or withholding documentation. Now, the point of this whole privilege, and again, this is an ancient idea, we want to encourage the free exchange and full and frank discussion of and regarding information by clients with their attorneys. Now, the reason that's important is, number one, attorneys need to have an entire picture painted in order to properly defend and or pursue a case. But number two, and in fact, in modern litigation, perhaps more importantly, counsel needs to be able to understand the full picture of what happened, the good and the bad, in order to value the case, and likewise advise the client regarding settlement as to how much a case is worth. If a litigant had to hesitate and think twice about sharing a damaging fact with counsel, then counsel might proceed with advising and recommending a settlement that is half or a third of what a case ought to resolve for. So it's best for everyone when clients can communicate confidently with their counsel in confidence. This last quote, I think, is a good one, and it's sort of dramatic, but it's very true, that the privilege ensures that one who seeks advice or aid from a lawyer should be completely free of any fear that his secrets will be uncovered. Okay, like any legal claim or doctrine, there are elements to the claim of privilege on a communication. Number one, the communications must be between a client and a professional legal advisor in his or her capacity. So it has to be between a client and a lawyer, and the lawyer has to be acting in that capacity as counsel in order to protect those communications. So it couldn't necessarily be a communication with a friend of yours who is a lawyer. You'll never guess what's going on here. This is going on in my case. We did this bad thing. If that friend or colleague or otherwise is not acting as counsel in that discussion, then the communication would not be privileged or protected from disclosure. Number two, the communication must be made in confidence. We're going to talk a lot about waiver as the presentation unfolds. A great misconception a lot of people have is that they could, for instance, go to a restaurant with their lawyer and then just share at a loud volume communications or other things with their attorney and expect that communication to be protected from disclosure. That's wrong. The communication has to be made in confidence. It's something that you don't want others to hear and that you are careful to make sure others don't hear it. I may back up. It's not necessarily going to be something you don't want others to hear. It could be a very good development on a case or something like that. But it has to be made in confidence, whether good or bad. Number three, and I sort of alluded to this in discussing element one, the communication must be made for the purpose of obtaining or rendering legal advice. Not all communications with counsel, even counsel acting in the capacity as your lawyer, are protected from disclosure. The communications have to be made for the purpose of obtaining or rendering legal advice, and that means the communications made by the client for the purpose of obtaining the advice and also by the attorney for the purposes of rendering that legal advice are protected. An easy way to remember this is the 5 C's of attorney-client privileged communication. I remember about 14 years ago when I was in the market for buying an engagement ring for my lovely girlfriend, now wife, I had to memorize the 4 C's of engagement rings: cut, color, clarity, and carat. Well, this is one more element. This is the 5 C's of attorney-client privileged communication. And we've alluded to this already, but it's actually an easy way to remember and something that you can think about before you send an email or a message. Number one, the communication must be confidential. It must actually be a communication by the client to his or her counselor for the purposes of seeking counsel. And again, I already sort of explained all of those elements before, but this is actually a really easy way to remember and something I recommend that you keep on hand if ever you have a question regarding the nature of a communication. Now, importantly, the attorney-client privilege does not protect underlying facts, and it does not protect the facts communicated. Only the communication itself that is made for the purposes of obtaining or rendering legal advice is protected. So you cannot protect from disclosure in litigation, the fact, something like, I'm an employment lawyer, so I'm constantly analyzing these types of questions. I saw Calvin Creep give Valerie victim an unwanted back rub. Well, the fact that that fact itself is not protected from disclosure simply because you told your lawyer. The communication with your lawyer is protected from disclosure. The other side couldn't ask your lawyer questions about it or couldn't ask you questions about that conversation. But simply communicating with your lawyer about something that happened does not protect that underlying event from disclosure. If, for instance, you are deposed and ask something like, did you ever see Calvin Creed inappropriately touching Valerie victim? Common misconception. In addition to the attorney-client privilege, which pertains to communications, there is also the work product doctrine. It's a different thing. They're often conflated improperly, but it's a different idea and a different level of protection for litigants. The work product doctrine protects materials that are prepared in anticipation of litigation, and it's qualified protection from disclosure. So, for instance, if your attorney asks you to prepare him or her a summary, or if your attorney directs you to go speak with someone and prepare a summary, that would be an example of a work product doctrine exception. We're not going to talk a whole lot about the work product doctrine today. It's not as central to the communication piece. But notably, an opposing party can still obtain on a showing of substantial need and inability to obtain information elsewhere. So that is a little difference from the attorney-client privilege itself from those communications. Those communications are sacred and protected and cannot be compelled to disclosure, whereas the work product exception is a little less stringent. Just a little bit more on the work product exception. Documents disclosing attorney mental impressions are not subject to disclosure typically. Now that is infrequently sought by the other side, but for instance, notes that I may take on a client call or notes that I may take in a witness interview, those would be my mental impressions and would not be subject to disclosure in litigation. And this generally provides a pretty strong protection. And it's broadly applicable and less likely to be waived, which we'll talk about here momentarily, when a communication privilege is waived. In addition to sort of the easy and generic examples of, let's say an email prepared and sent to your lawyer, there are also, or we can also claim privilege on documents and correspondence that reflect an attorney-client privilege communication. This probably comes up a lot in the HR world, and I see it a lot when I am gathering and reviewing documents and analyzing whether they should or should not be produced in the course of litigation. Often in the investigation context, we'll see emails like the example we gave, an email between two management-level employees, like let's say Irene, Inspector, and Connie, Compliance, that say Larry advised that we suspend Calvin Creed's employment immediately. Now, that email in and of itself would not pass sort of the initial test that we gave you, or the 5 C's of attorney-client privilege communication. However, it is an exception, or I guess not an exception, it's another element to this doctrine, that a communication reflecting the lawyer's advice is protected from disclosure. Now, importantly, and sort of practically, it doesn't necessarily protect the entire communication, right? If Irene writes Connie a 10-page memo about what happened, and there are 3 sentences referring to Larry, lawyer's advice, we couldn't turn around and claim, oh, sorry, the entire memo is protected from disclosure. Those sentences or lines would be redacted with some type of notation that says they're protected from disclosure because it reflects that privileged communication. But very important for you to understand as human resources professionals, and I will tell you, often in my job as an associate at a large law firm, the task of gathering and producing documents falls to me. I have to be very, very careful that I don't get complacent in reviewing, for instance, exchanges between human resources, that I don't just see, oh, it's simply HR professionals, we're just going to produce this document. It's important that I get my eyeballs on every single line and sentence within that communication for this very purpose. And, sometimes we might use an attorney's name as a search term when we're doing electronic searches. that helps. That casts a fairly wide net to gather up privileged communications and make sure they're not produced. But it's not completely sufficient. It's important that I get my eyes on every single line within that memo. And I would advise often my clients who like to handle these document productions more in-house, make sure your folks are reviewing the memos and emails top to bottom for any communication that's reflecting communication or a lawyer's advice. With that, I'm going to turn it over to Stacy for our first poll question.
Okay, our first poll question involves a hypothetical. Company received a cease and desist letter from a competitor claiming that the newly hired director of sales has violated non-disclosure and non-solicitation agreement obligations. The company gathers relevant documents for counsel and labels them as confidential, attorney-client privileged communication. The company also prepares a timeline of events that occurred. The company sends the email to the company's counsel, providing some background information and setting up a call to discuss the matter. Attached to the email are the letter from the competitor, the evidence the company collected, and the timeline. So here's your poll question. Is any of the evidence that the company collected privileged?
All right, we're going to give you all a few moments here to say yay or nay. And I would urge you to focus on the word evidence in the question there. A few more moments here.
All right, it looks like the majority, let's go back. All right, looks like the majority of you answered correctly. No, the underlying evidence has been explained is not protected from privilege or is not protected from disclosure merely because it was attached to an email that was sent to an attorney. Now, here's a bonus question for you, however. What about the timeline? Would that timeline be protected? Well, this falls under the work product doctrine. This would probably be protected because this is something that was prepared in order to assist the attorney in defending the matter. It was prepared in anticipation of litigation. So that's another good thing to remember about the work product. Sometimes we call it attorney work product, but it doesn't always have to be work that is produced by an attorney. Okay, we're going to focus a little bit in these next slides about who speaks for the corporation or the company and whether those persons are deemed to be within the relationship with the attorney such that those communications are privileged. As we all know, clients can be humans and they can be companies, and companies can only speak through their representatives. So naturally, it's easy to know that a communication, for it to even to be thought of as privileged, there has to be an attorney on one end of the communication. But what about the other end? Who in the company can speak with the attorney and expect that communication to be privileged? Well, we have current employees, and we'll talk a little bit about former employees next. But first of all, for the current employees of the company, it used to be there was a more narrow test that courts would use to decide whether this particular employee who's speaking to the in-house or outside attorney is able to claim privilege. Well, there was this control group test that protected communications only by employees who exercise direct control over managerial decisions. So this was more of a determination of what role the employee served in the company, whether that person could be deemed to be speaking for and on behalf of the company. But the more predominant and the current test is called the subject matter test, or more commonly we just call it the Upjohn test, taken from the case of Upjohn Company versus U.S. It's back from 1981, so it's been around a while. So in Upjohn, the Supreme Court rejected that narrower test and found that communications between the company's attorneys, whether in-house or outside, and employees that were not in managerial positions could be protected if 4 conditions were met, and these are laid out on the slide. Number 1, the communication needs to be made to the attorney at the direction of the employee's superiors. Number 2, the communication should concern matters that are within the scope of the employee's duties or knowledge. 3, the information is not available from upper-level management. And 4, the employees are aware that they're being questioned by the attorney so that the company can obtain legal advice. This is a great common sense decision. And so these are good reminders too. A lot of us are familiar with the test, and we know that non-managerial employees can speak to the attorneys, but these 4 elements are good reminders to ourselves and to the employees. If you're going to bring in a lower level employee on a matter, for instance, to educate the attorneys on what happened, when they typically don't speak for the corporation, make sure that there's an indication that it's done for the purpose of legal advice, and you want to make sure that the employee's superior is aware of the communication and that the superior is, in a sense, directing that lower level employee to speak to the attorneys. That will help make it crystal clear that this communication should remain privileged. Okay. Now, former employees. This gets a little more dicey. Conversations with former employees by the company's attorney may be protected if the communications are about some knowledge that the former employee obtained while he or she was employed. Or perhaps it could be about conduct that happened when the former employee was still employed. Also, it could relate to communications that were done or that were communicated during the employment relationship. So, in other words, the attorney-client privilege is not broken just because the employee leaves the employment. This should not be confused, however, with the question of whether an employee, after leaving employment, is considered to be still represented by the company's attorney. So former employees are not insulated from contact by an adversary's attorney. So, somebody leaves the employment, they knew about something that happened, and then your current employee brings suit against the company for discrimination, and plaintiff's lawyer wants to talk to the former employee about the matter. Well, in most states, that plaintiff's lawyer can speak to your former employees. They do have a couple of duties. The plaintiff's attorney has to advise the former employee that he or she is representing the plaintiff, the current employee, and has to advise of his or her interest in the litigation. And also, plaintiff's attorney must direct the former employee to avoid disclosing privileged or confidential information. So it's just important not to confuse those 2 matters. The privilege generally remains intact. If the privilege attached while an employee was employed or relates to information that he or she obtained while employed, generally that privilege will persist. It doesn't break up just because the employee left the company. All right, now let's talk about mixed communication. So what conversations are privileged? What types of conversations? So communications often have multiple or mixed purposes. Especially you in-house attorneys, you wear many hats. You are sometimes a legal advisor, but sometimes you're a business advisor. So in the case of In re Kellogg, Brown, and Root, the district court found that KBR's internal investigation documents were not privileged. The court said that KBR had not shown that the communications relating to the internal investigation would not have been made but for the fact that legal advice was sought. So this was a very strict test. I mean, this essentially would have required a company to show that it only conducts investigations to obtain legal advice. And as we all know, companies perform investigations for many other reasons, not just to comply with the law, but to improve morale, to ensure employee loyalty, just to do the right thing. Fortunately, the Court of Appeals for the D.C. Circuit reversed that but-for test in favor of a test it called the primary purpose. So now, when you have a mixed communication that has some legal advice and then some non-legal advice, the court will ask the question, was obtaining or providing legal advice a primary purpose of the communication? So meaning one of the significant purposes of the communication. So this is a much better test. So the risk here, though, is that what constitutes significant, what constitutes primary purpose. And also, this leads into some questions about when and how and risks of redacting and how to do that. We'll have a hypothetical for you on that later. And now, Ben, we'll talk about waiver.
Thank you, Stacy. Okay, we've talked a lot about the importance of confidentiality in preserving the privilege, and it is critically important. This is where things can get really interesting when it comes to waiver. A client or an attorney can expressly waive the privilege or can be deemed to have constructively waived it through, one, disclosure of any part of that communication to a third party, or stated more broadly, an individual to whom the privilege does not attach. Number two, through the production of privileged documents, and that is the thing that keeps associates up at night. That's obviously a less than ideal thing that happens. Oftentimes it happens inadvertently. Sometimes it happens through sort of a misanalysis, if you will, of whether a document should or should not be withheld. The third way, among others, is through deposition testimony. If a deponent starts to talk about advice given to her by counsel and counsel doesn't object at that deposition, that can waive the privilege to the remaining communications in the case. Number four, when the legal advice is combined with or otherwise provided for a specific business purpose. This can occur and can be difficult to decipher when an employee wears two hats. And sometimes we see this at smaller companies, sometimes we see this at bigger companies. An individual who has a law degree and sometimes counsels the client, or typically this is an in-house employee, who sometimes may counsel the client on legal issues, but also serves, whether predominantly or additionally, in a human resources advising role or just a general business advising role. Those communications can be difficult to decipher. I want to go back to number one, disclosure of any part of the communication to a third party. I think a lot of people have the misconception that they can share or disclose something that their attorney told them with someone else and thereby preserving the privilege as long as they don't share it with the other side. Well, that is wrong. And we're going to talk about a case here in a moment where that specific situation played out. Technically, and folks, rarely does it come to this in litigation, but technically, if you are at a ballgame with a friend and you're just having small talk and you won't believe we're getting sued and this happened and by the way, my lawyer says this, or we told our lawyer this and she says this. By having that communication with a third party who is not a part of the client, you technically waive that privilege, and there are the occasional horror story of things like that happening. The production of privileged documents, now often when that's inadvertent, that can be subject to what we call a clawback agreement, and in that case you don't waive the privilege. Basically an agreement between the parties that privileged documents inadvertently produced will allow the parties to claw those back or get those back without waiving the privilege. But if the document is intentionally produced and there was sort of a misanalysis, as I said, or a miscalculation of whether it ought to be withheld, then you can waive the privilege through that. So waiver is a very important piece of this that pertains to the confidentiality of those C's we talked about earlier. The case I mentioned, Total Recall Technologies versus Lucky, I guess, interesting spelling of Lucky. That was out of the Northern District of California last year. the court held that disclosure of privileged information to a third-party business confidant waived otherwise applicable privileges. Now, I suspect I know what a lot of you are thinking. There can be different advisors that the privilege can attach to. And typically we'll enter into joint defense agreements or things like that, like perhaps an accountant retained, or an expert for sure retained to provide communication or analysis on a case. So there are exceptions to that, but simply, let's say someone you went to MBA school with that you typically talk with about your business and get advice from, that individual would not be a client for the purposes of these communications, and communication of that protected communication to that person could theoretically waive your right to protect that from disclosure. All right, let's take a look at our second poll question, and that goes back to, this is a bit more esoteric, to what types of employees can be considered the client for the purposes of attorney-client privilege communications. We looked at two different tests earlier, and the question we have for you now is, which test, between the control test or the subject matter test, is the prevailing test to determine whether a non-managerial employee's communications with in-house or outside counsel are privileged? I'll give you a few minutes to think about that. A few moments, I should say, not a few minutes. We don't have that much time. All right. It looks like the majority of you answered correctly that it is the subject matter test. That's the Upjohn test. We've got a few slides, I think slides 14 and 15, discuss those two tests and the development of those tests in detail for anyone who wants to look that over. All right, we want to move on now to sort of some practical pointers on protecting the attorney-client privilege and those communications from being disclosed. Number one, just be careful regarding who is copied on emails that you intend to protect as privileged. Our advice is to just really think critically about whether the individual is on a need-to-know basis. Now, for efficiency purposes, it often makes sense to copy as many people as you can on a communication. However, attorney-client privilege communication should receive a different analysis. Efficiency is not our objective here. The protection of the privilege is. So think very carefully about, number one, whether the person that you're copying would be considered the client for the purposes of the privilege, and number two, whether or not they even need to be copied. Is this something that I can just share with them later on? I want to talk with you now about practical pointers when conducting investigations. An important decision you need to make when there's something going on in the workplace that needs investigating is whether to conduct a privileged or discoverable investigation. And that's going to turn on whether an element of the plaintiff's claim or perhaps our defense might turn on whether we properly conducted an investigation. Easiest example of this, we'll call it the NBC situation, with everything in the news about Mr. Lauer, is cases of sexual harassment. There's an affirmative defense that we often plead, and also just a general defense of the case that, look, as soon as we heard about this, we conducted a detailed and thorough investigation and took prompt and effective remedial action. Oftentimes, we want that investigation disclosed. We want to show how thorough and careful and aggressive Human Resources was and prompt in investigating these allegations, and in particular when the results of the investigation are favorable. That's something that you're going to want to have produced in most cases, and in that case you want to conduct a discoverable investigation. On the other hand, if there's no real legal duty to investigate that claim, and the results of the investigation might be something we don't want to broadcast to the world, conducting a privileged investigation might make more sense. For instance, employee is accused of embezzling something, or employee is accused of being unkind or cruel to coworkers or stealing or whatever else. Maybe not something that we want broadcast to the whole world. In that case, it might make more sense to have a privileged investigation conducted, i.e., in often cases, an investigation conducted by outside or in-house counsel. kind of in the same vein of what we talked about earlier with copying, folks. Boy, in 2017, there is just such an urge to forward everything, copy everybody. Just be careful about who you forward emails to, particularly if they, well, and especially if they include down the chain advice from counsel. The whole privilege can be waived if an otherwise privileged exchange is forwarded to an employee or individual who is not in a position to have a privileged communication. This is no different than if we were to go up and share the content verbally of that privileged communication. Now, that's obviously going to be more difficult for the other side to get at, but be very, very careful about who you're copying and who you're forwarding emails to. I'm going to turn it over to Stacy for some more practical advice.
Okay, so going back to basics, really, we live in a world where we're so busy. It seems to be easier. Most people think just to shoot an email out or, in some cases, text. We really need to educate our employees and ourselves that it's often better and it's safer from a litigation risk perspective to, especially if it's something sensitive, if there's going to be, legal advice involved, just to pick up the phone. So that's something that always has to be considered on our own part, and also we need to educate and train our people on considering what they write before they, think before you speak or think before you write. We should always ask ourselves, well, how would this look if this email were laid out for the judge and jury to see, or if it were attached to a pleading and placed in the public domain on PACER? So that's a good reminder. Also, when you're taking notes during a meeting with counsel, I always advise people to make sure, if you're going to take notes, put the date, obviously, but head it by saying this is a meeting with Joe Smith, attorney. You need to identify who that person is, advising on, and then you can put the subject matter of the meeting. And then below that, you can put other attendees. And these are just practical points for you to think about, so that later on, when your attorneys like Ben or me are collecting those documents, it's easiest for us to see that these documents are privileged. Same thing here. When you're communicating with your attorney, we like to put at the top attorney-client privilege so that it's very clear that you intend for this to be protected. Of course, simply putting that at the top does not in and of itself protect the communication from disclosure, but it does help flag it as something that you intend to be kept from disclosure. You want to avoid using phrases like FYI, so just forwarding something to your attorney without explaining the need or the request for legal advice. So you can say, Larry, what is your opinion? What's your advice on this issue? Something like that. And finally, remind the email recipients of a privileged email chain to reply all to avoid omitting the attorney. Now, we don't want to go overboard. If we start copying attorneys on every single communication, then that could lead to a finding by the court that you're merely trying to withhold documents that would otherwise be discoverable. So, and also consider that, just doing that, just copying the attorney doesn't make it privileged, as we've already explained. But also, sometimes there are helpful documents to your case. These are favorable communications. You don't want those to be withheld. So why copy the attorney? Now, if this relates to what I was talking about earlier, about if you have a communication that has a mixed purpose, best practice is to separate those out. We talked about the test from the KBR case, the primary purpose test. Because that is subjective and because courts can disagree on what is the predominant or for that primary purpose of a certain communication, whether it's legal or not legal, better just to avoid that issue altogether and separate your discussions. Keep your legal discussions to the legal matters and save your business communications for a separate email. Make it company policy to remember to remind the employees that their responsibility is to the corporation. and that privilege with legal counsel is not absolute. So the privilege belongs to the company, and they need to understand that, and that the privilege can be waived by the company even if it might expose the employees to liability. We have to make sure employees don't expect absolute confidentiality of everything they tell in-house or outside counsel. And just basically instruct employees on how to retain the privilege. And I'm sure you all do that, especially with those that often work with the General Counsel's office. I want to talk a little bit about drafts. And this is sort of back to the beginning, but it's a good reminder that in discovery, so if you're asked to produce a certain document, let's say you're asked to produce the investigation summary, you can't just produce the final version. The drafts of that investigation summary are separate and unique documents that also need to be produced. So if you want to protect your drafts from disclosure, then you need to make plain that those drafts are being circulated for comments on legal issues. One good way to do that, again, this is just practical advice, put a legend at the top or do a watermark or something to say that these drafts are attorney-client privileged. You can also put work product for that matter, because the draft is most likely being prepared to assist the attorney in the defense of the case and at counsel's direction and in anticipation of litigation. And then, of course, when the document is put in final form, you could remove that legend. Of course, some of this may depend on, as Ben was talking about, whether you're trying to create a privileged or non-privileged investigation. So it's some examples. You can read these: disciplinary memos, communications about leaves, and be careful with communications with terminated employees. Okay, I'm going to turn it back over to Ben.
Thanks, Stacy. Okay, I want to just give you all a little flavor of how the courts have chimed in on this. And again, this is all going to be a bit repetitive of what we already talked about, but this was a case out of New Hampshire in which the court held that, quote, documents prepared by non-attorneys and addressed to non-attorneys with copies routed to counsel are generally not privileged, since they are not communications made primarily for legal advice. And again, this is simply the forwarding on of emails, the FYI, things of that nature. Those are not made primarily to obtain or render legal advice. Another way of putting it, which is absolutely true, a corporation cannot be permitted to insulate its files from discovery simply by sending a CC to in-house counsel. You'd be surprised how many folks think, well, good thing we don't have to produce this document. The lawyer was copied on the exchange. That is simply untrue if the document is otherwise not discoverable. Or I'm sorry, is otherwise discoverable, my mistake. Well, again, right next door, out of the District of Kansas, the mere fact that an attorney attends a meeting does not render everything said or done at the meeting privileged. I think Stacy talked about this a little bit. The simple presence there of counsel does not make the entire meeting protected from disclosure. Where we often see this, and in my world, when I'm gathering and producing documents, is meeting minutes. Meeting minutes that will mention that an attorney is there. Oftentimes there's a misconception that, okay, I see the attorney's name as an attendee, therefore we don't have to produce the document. That is not true. In those cases, I or you, depending on who's handling that, has to go through and be careful to redact any reflected communication or discussion in that meeting where the lawyer is either asked advice or provides it. All right, that gets us to poll question number 3. Communications seeking and or containing both business and legal advice are generally considered privileged. Communications seeking and or containing both business and legal advice are generally considered privileged. What do you think? That was fast. Give you a few more moments. All right. So in theory, that's true. However, whether the communication is predominantly for legal advice is a subjective inquiry on which courts can widely differ. So the lesson from that is, again, to advise caution. To the extent you can segregate those communications between those in which you're seeking business advice and those that you're seeking legal advice, you should do so. All right, we want to work through some hypotheticals here, and we're coming up against the end of our time here, so I'll try to move quickly. Let's go back to our hypothetical. Irene Inspector's initial message, in which she says, on which Larry was copied, FYI investigation summary. The body of the email says, like, my plan is to follow up with Valerie, and I think we should suspend Calvin immediately. His behavior was inappropriate. Again, a reminder, at no point in that email does Irene ask for anyone's advice or input. I think you could argue, probably effectively, that that initial message is not a privileged communication. And the second question, what would have made it privileged? Something like, Larry, I'm seeking your advice here, or this is just a draft. I'd like to know legal's perspective on this. Something like that, something indicating, hey, I need some advice here before this is a final copy or something that we're ready to close out. How about Connie's response with, I agree, Connie Compliance, the Director of Human Resources. I would argue that that response likewise is not privileged and that it is not provided or communicated for the purposes of obtaining or rendering legal advice. And likewise, the very damaging exchange between Connie and Sally about Calvin's value, where Sally says, whoa, 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 this is my top performer. He's got a huge sales call at the end of the month. That's a terrible communication that you want to be asked about in a deposition. But again, I would argue that since there is no legal advice sought by that non-lawyer, that that communication is discoverable and not protected, regardless of whether Larry Lawyer is copied. Okay, a couple hypotheticals here to quickly work through. The company is going to terminate an employee and is considering offering a severance package. The Human Resources Director emails the in-house and outside counsel to assess the risks and severance options. After consultation with in-house counsel, outside counsel responds to Human Resources via email. Now, Human Resources forwards that email, the email from outside counsel, to the CEO, copying outside counsel and saying, see email from counsel below, let me know your thoughts. Is that communication privileged? I would say yes. Number one, it reflects privileged advice, and it's also actually the forwarding on of that email from outside counsel. Number two, in thinking about this hypothetical, the CEO forwards an email to the CEO, copying HR, and states, I'm fine telling counsel 3 months of severance in COBRA, but nothing more. Privileged? I would argue yes, and again, that it is reflecting legal advice. CEO responds to CEO and states, I agree, but I'm concerned that she could cause a lot of turmoil and dig up some more skeletons if she sues, so I'd be flexible in offering even more. This one is probably a maybe. Is he seeking to obtain legal advice on this exchange? Is this reflecting privileged communication? This one's more difficult. This last one, if the CEO emails and states, what a joke, the squeaky wheel always gets the grease, likely not. Not reflecting privileged communication and not seeking to obtain or render legal advice. Go on to one that I see a lot, actually, and one that I'm really beginning to advise my clients strongly against, and that is the inclusion of certain documents or notes in personnel files. This company is working with counsel to manage an underperforming employee we will call Steve. After meeting with Steve, the following note is placed in his personnel file, and this is by HR. I met with Steve today. I followed the script that company counsel and I prepared last week. Red flag number one. Counsel and I discussed offering Steve a transfer to a different sales team so he can have a fresh start. Red flag number two. We also discussed addressing Steve's performance issues, which Steve was not happy to hear and immediately became defensive. Counsel and I had discussed how to handle Steve's reaction and steer him back to the point where he could have a productive dialogue. I tried, but I could not get Steve engaged in a constructive discussion about his performance issues. As recommended by company counsel, red flag, I gave Steve a copy of the company's retaliation policy and told him that the company does not tolerate retaliation and that he should report any indication that he is being retaliated against. Is there any issue with the company putting the note in Steve's personnel file? Answer, yes. This could result in a waiver of the attorney-client privilege. We have a real-life case to work from here, McGee versus Parker Hannafin up in Michigan. After plaintiff McGee was fired, she requested and received a copy of her personnel file, which contained 2 emails between HR and legal counsel regarding McGee's FMLA leave. McGee sued the company and attached copies of the emails to her lawsuit. Gotten her hands on them. The company asserted that the emails were privileged, but the court disagreed, reasoning that if HR was careless enough to leave the emails in the file, then the company gave up its right to rely on the privilege. This is something that I have seen a lot, and I understand. Oftentimes you HR folks are in that role because you're highly organized and you are careful to document and file things. We strongly recommend that documents containing privileged advice or privileged communication not be put in a personnel file. That should be put in a separate file that we can cull through later and decide if they're discoverable. Number one, it's just a difficult analysis to engage in. And number two, depending upon your company policy, the personnel files might be accessible by a lot of people, including the plaintiff, his or herself. So we advise strongly against doing that, whether that be emails or otherwise. Okay, I think that's going to bring us to, we had a few more questions, but we're out of time. We want to very much thank you all for your participation today. We've seen a lot of questions that have come in. We'll do our best to think about those and possibly get you an answer. I'm going to turn it over to Ashley, who's going to give you some closing remarks. And again, we thank you all very much for attending our presentation. We sincerely hope that it was helpful.
If you've not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. This program has also been approved for HR Certification Institute and Society for Human Resource Management recertification credit. Recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. This concludes our webinar. Thank you.